introduce Dan Ahearn. He has a number of titles here: Director of Outreach, Assistant, Head of Schools, Legal Counsel. He's been a BSEI Hearing Officer, ran the BSEI? Oh my goodness. So, and he teaches a lot of class. So that's why we have him here to talk about the latest stuff that's happening within our state and also federally. So there's a handout that's going around. Dan is awesome. He has a lot of resources. So I already gave them ground rules of like privacy and here and live stream and all that. So take it away, Dan.
Okay. Morning.
Morning.
So thanks for inviting me back. I've been doing this every year for a while. How many people have heard me before? Sorry.
No, we're back.
We're
back. Repeat. I learn something new every time.
Okay. I'll try to make that happen again. So the idea today is to try to go through a lot of material in a short amount of time. And I'm happy to take questions as we go. We'll try to move it through. We have about an hour to kind of make this work. So the handout is pretty straightforward, and this is actually good that I'm a little bit later than usual because it takes me a while to warm up. I teach a class usually at night right now, and I don't teach at 8 o'clock because I'm not coherent at 8 o'clock. So it's actually good. The longer I wait, the better. So I also teach a couple of classes here. I teach a language arts class, a U.S. law class with the kids here, and the student advocates program. So the nice part about that is it keeps me connected to the kids. And it's usually a positive thing. They're great. We have a lot of fun together. I have all seniors, so we're in the midst of applying to college and getting senior grades in and all that stuff. So they're a little stressed right now. So they get a free period to kind of chill and catch up on their homework, which is a good thing. While we do this, so we're going to move through this fairly rapidly. This is a handout. This is a blueprint that I use for virtually every session that I do. And I do a fair amount of these sessions around the state for PACs, for SPAN, if you know SPAN, for attorneys in Boston. I do 2 of these sessions a year for the Mass Bar Association, basically updating lawyers, advocates, parents around what's going on with the legal issues in special education. As Angela noted, I teach this class at Suffolk Law School, a disability law class. So I try to stay up to date. That being said, the past 3 months legal issues in terms of the BSEA, I haven't scanned those yet, but I have everything else in here, so you'll see that. So if you look at this, the way it's structured, I actually numbered the pages. That's a big deal for me. On page 2, you'll see how it's set up. That's kind of an overview, and at the bottom of each page, what I want to point you to, it says key new legal points, statutes and regulations, and policy and guidance. What I try to do there is kind of capture what's going on around the country, literally, in terms of special education over the past year. So I actually, it sounds really boring, and it sometimes is, I read every single case that comes out over the course of the year involving special education law. And I look for trends and patterns and key issues. I also look at the legislative stuff coming out of Washington as well as Massachusetts. And I look at what are called advisories coming out of the Federal Department of Education and the State Department of Education. And I try to put that all together in kind of a coherent way here, compartmentalized. And the idea is to give you guys a resource so that if at some point, if you're dealing with a district and you have some issues with your child getting services or whatever, you can be able to point to certain parts of this and find the information that you need, both in general, because this is a general overview, as well as specific trends or activities that have happened over the past year or so. So that's the idea. That's the blueprint of this handout. So if we do this, we're going to kind of walk through this in a pretty straightforward way. On page 2 is just the key laws that you need to be aware of. I'm not going to spend a lot of time on that because I think you know what they are. The IDEA, Individuals with Disabilities Education Act, is the federal law providing that your child gets a free, appropriate public education in the least restrictive environment, and that becomes important. And we'll talk about that a little bit later on. IDEA is way overdue for what's called reauthorization. It's supposed to be reauthorized by Congress every X amount of years, usually every 5 or 6 years. it's about 15 years overdue right now because Congress, as you're well aware, can't seem to get a lot done. There's always new proposals introduced every year around the IDEA that don't really go anywhere. However, this time around, you should be aware that the Department of Education at the United States level is proposing to look really heavily at the IDEA at this point and pull the federal government out of the IDEA special education business and return that authority back to the states. That's not a good thing in the big picture. So just be aware of that. Though. That information has trickled out over the past month that the federal Department of Education is considering amending regulations, changing policies to give more authority to the states. A lot of people feel that that would be a mistake. The reason we have the IDEA in the first place is because states are not doing their job on educating kids with disabilities. So just pay attention to that trend that's emerging right now. Section 504. How many people have dealt with Section 504? A couple folks. Usually you hear Section 504. Sometimes initially when your child is seeking services, they may say, let's put your child on a 504 plan versus an IEP. Or in the alternative, they may say, your child's doing really well on an IEP. Let's move him or her to a 504 plan. So that's where that comes up in context. But in tandem, those are the two big special education laws. If your child is transitioning out of high school and going to college, Section 504, and I didn't put it on here, the Americans with Disabilities Act become really key for them in terms of their ability to get services in college. So you always want to remember 504/ADA is the triggering mechanism for kids going to college, coming from Landmark or any place. But it's really important for them to understand their rights. And I talk to virtually every senior class here at Landmark, giving students advice and guidance on how to advocate for themselves. Because as you know, or you will know, you get the bills for college, but you get no access to information about how your child is doing in college. So it really falls on them to advocate. And the ADA and 504 are the key tools for them. State law, Massachusetts is Chapter 766 or Chapter 71B. It's the law that drives a lot of everything that happens in Massachusetts. Comprehensive, mirrors the IDEA almost exactly. Okay? Now key legal points down here, just to kind of reference this quickly. The biggest thing we're seeing here, and it doesn't really deal directly with kids with disabilities, but it deals with the broader issue of sexual misconduct, sexual harassment, bullying kind of issues, and what we're seeing out of the feds is a withdrawal of all the Obama-era policies around the rights of individuals who are transgender, around sexual identity, and around how claims of harassment are going to be handled. So, as recently as 2 days ago, the Federal Department of Education and HHS, Health and Human Services, is proposing new guidelines around the definition of gender for kids, and that impacts the rights of transgender individuals in terms of access to program facilities. If you're in Massachusetts, you know it's question 3 as well. Even if the federal government goes to a biologically based definition of gender, state law will still control, because the rule of thumb is that whatever law gives the most protections to an individual will control in terms of civil rights. So if federal law gives more protections, federal law controls. If state law gives more protection, state law controls. So regardless of what happens federally in terms of gender identity and these policies that are being withdrawn and then reissued, if Massachusetts votes in favor of continuing to protect the rights of transgender individuals, then Massachusetts law will still continue to do that, regardless of what the feds do. Does that make sense? Okay? So just be aware of that trend in terms of where the feds are coming from in terms of these issues around Title IX and stuff. We good on that? Okay. Fastening the seatbelts, right? Because we're moving. All right. Page 3, Section 504. This is just the background information for you. In case you encounter a Section 504 issue or proposal by the district to have your child on a 504 plan, this gives you the background and the context for that. And I'm really not going to spend a lot of time walking through it. I just wanted to have this information available to you. But you can see Section 504 is a civil rights law, meaning it protects people with disabilities from discrimination. It's not like the IDEA and 71B in Massachusetts, which is special education. Special education is an entitlement law. 504 is a civil rights law. The difference being, once you are eligible for services under the IDEA in special education, you are entitled to those services. Your child is entitled to those services. Meaning they can't say they don't have the resources, they don't have the personnel, they don't have the program. They must create the program to meet your child's needs. Or send them to them, for example. 504 is civil rights. It means that your rights are being violated by the school based on your disability. And it's a different kind of approach to the way a child will be treated. It means that there are claims that you can file against the district for denying them services because of their disability. So it's a different lens to look at, and this statute kind of spells it out. And you have to have a physical or mental impairment that substantially limits a major life activity. And the definitions are all laid out for you here, kind of step by step. But just recognize that if your child is eligible under 504, they would get a 504 plan, which is a document that describes what their disability is and describes what accommodations or modifications might be necessary for them to succeed in school. So it's very similar to an IEP, but it's a little different animal. What you should recognize is that 504 plans are generally a lot shorter, and a lot less detailed than an IEP. An IEP, I have a kid who's, I represent kids in foster care. So I have a kid who's a client in the Boston Public Schools right now, and I got their IEP yesterday. Fax scanned to me, and it's about 25 pages, okay? Pretty comprehensive IEP, child has autism, looking at some transition issues. 504 plan could be 2 pages. So it's a very different kind of piece of documentation to be aware of. You can get the exact same services on a 504 as you can get on an IEP, but there are less protections. Under a 504, you don't get stay put. You don't get the right to an independent evaluation. So there's some substantial issues that are different between 504s and IEPs. So just file that away in the back of your mind. Most of you guys aren't dealing with 504, but if it comes up in conversation with your district for whatever reason, for whatever child you have, recognize the differences between an IEP and a 504 plan. Generally, I would recommend legally that you stay on the IEP. There's just more substantive protections there available to you to protect your child's rights on an IEP versus 504. But can you get the same services? Yeah, you pretty much can. Okay. A couple things on the bottom here of page 4. Just to be aware, these are key new legal points. The Pollock one, the second, we're not going to go through all these. The second one down is just an interesting concept that was raised in this case. This is a situation where the district and the parents had, the relationship had entirely broken down. Sometimes that happens, occasionally. It had entirely broken down, and the parents weren't comfortable with what they were hearing from their child about what was going on in school, in terms of the teachers, the students. So what they wanted to do was they wanted their child to carry a recording device all day long, and to bring that to class, to bring it to recess, to bring it outside. The district said, as you can imagine, not going to happen. Went all the way up to the First Circuit in Massachusetts, which is pretty high up, one level below the Supreme Court. And First Circuit last year basically said that's too much. That's not permissible. It doesn't get to the educational needs of the child. It's more of a kind of monitoring device versus an educational device. So that request was denied. It's kind of an outlier. But you do hear periodically about recording team meetings and those kind of things, which is clearly allowed. But recording the actual what's going on in the class on an ongoing basis, the court said that's a little too far. Okay. If you turn the page, there's one more on page 5. This is out of Wisconsin. Bovey Eau Claire area school district. So let me give a little context here. There was a case called the Fry case the year before, which is referenced on the bottom of page 4, that dealt with the issue of whether parents could pursue a claim under, this is gonna be a little bit more complicated than you wanna hear, but it's important. Under the Fry case, the Supreme Court said that a parent could pursue a claim under 504 without exhausting the IDEA remedy. Stay with me. That's important because 504 allows monetary damages. So lawyers have always tried to double track, 504 and IDEA claims in every case. So if you're working with a lawyer or an advocate, they will likely, if they go to the DSCA for a hearing, they will likely throw in a 504 claim, an ADA claim, an IDEA claim, etc. And the courts have always said, if they're overlapping, you can't do both. It has to go under special ed. The Fry case said in certain situations, you can actually pursue a 504 claim. That alarms school districts, in all honesty, because it's monetary damages, which are not available under the IDEA. So, the context here in this case that I just referenced, for Bo, it's one of the first cases interpreting Fry. And what this means is that in the context of a claim for harassment, the court said that that's an example of a case where you could pursue potentially dual remedies. And the reason I reference the case is not so much for all the legal technicalities that I just walked you through. It's because one of the things that we're seeing, and if you read my blog like a week ago, sorry. I don't actually like to read those, do those. I was asked to do it by the outreach program because I'm the director of the outreach program. I wrote the blog thing. But anyways, in that I referenced one of the trends that we're seeing is an increasing amount of claims of harassment of kids with disabilities. So, in addition to bullying claims. So part of the mix here is that the courts are recognizing that when a child with a disability is getting services, but is also getting harassed by peers, that rises a separate claim from the services under the IDEA that can be treated distinctly. So it's just something to think about in terms of context, because we just did a present student advocacy over at Endicott College last night, talking to Endicott College kids, and they get up there and they talk about their personal experience. And one of the things they talk about is being, called sped, or being, not treated very well by their peers in their old environment. So, and I hear it all when I coach the soccer team, which I also do here. The kids come off the field and they say, the other kids are calling us retards. And they're calling us names and they're harassing us. So the point here is that the courts are opening up some venues here where kids are being harassed or bullied based on their disability. There are now opportunities to pursue that a little bit more aggressively with schools to help them recognize that this has to stop. So it's just another tool that's available to parents and attorneys and advocates to make sure that those kind of things don't happen. Okay? Questions about any of that so far? All right. So on page 6, we talk about eligibility, and now we're shifting gears into the actual special education part of the world versus 504. For eligibility purposes, everybody here, we're not going to spend time on this either, because everybody here has a child who's eligible for special education, right? You have a specific learning disability that impacts their ability to make effective progress in school, which is why they got eligible for an IEP. And you can see here the definitions and how it all lays out. Ages 3 to 22. When does IDEA eligibility end? 22 or graduation. I always tell the kids, I did a workshop on Tuesday with the kids. So once you walk across the stage in 6 months or so, believe it or not, and you grab that diploma from Mr. Bruto, you're done with your IEP. It's over, okay? So fundamentally, it's important that they understand that, because it transitions to that 504 ADA lens for college. But this talks about eligibility, how long it lasts. There's a definition of specific learning disability, right there in the middle of the page, under this part C. That's the exact definition of SLD, as it's called, and that's what shows up on your IEPs. That's the box that gets checked off. issue that's arising right now is the whole concept of dyslexia and dyscalculia and dysgraphia as specific subcategories within SLD. Now you can see in that definition, in part C, about the second line from the bottom of that definition, you can see dyslexia is specifically referenced under SLD. However, the argument that's going on, the debate that's going on successfully around the country is to introduce state legislation that will specifically allow districts to include dyslexia specifically on an IEP. Okay? Because right now it's SLD. And the idea is that if dyslexia is named specifically as a disability category, then teachers and districts and personnel will better recognize what particular needs are of that child. Because you have to recognize, and you guys have all experienced this, teacher may have 20, 25, 30 students in a class, 10 of those kids are on IEPs, 2 might have autism, 2 might have behavioral, 3 kids might have SLDs. Do they have an opportunity to read those IEPs really carefully? Maybe, maybe not, right? But if they know that the child has dyslexia versus this broad definition of SLD, maybe the interventions will swing in more effectively and sooner. That's the idea. Many states have adopted the new terminology around dyslexia. It's all fluctuating all over the country. It's proposed in Massachusetts. It did not pass during the last legislative session. It's up again with a new proposal, so that's something that you all could pay attention to, and I know Angela will pay attention to it as well, in terms of the status of that particular piece of legislation. The idea is that it attracts more attention to the issue. And you can see, if you turn the page.
Dan, can you just talk about the need for arguing for an SLD or diagnosis, category, because lots of times our kids are categorized as health, or I see that a lot with kids.
Yep.
And I'll spend an hour in an IEP meeting
Right.
saying, no, it's SLD, we have to change this category.
So there's a, if you look at the list, and I think it's on here, there's a list of quote-unquote disability categories. Number 1, under definition on page 6. You see a list of what a disability means, and those are called the disability categories. And within that, there's one called other health impairment. And that's kind of the catch-all. So, as Angela just noted, it becomes important to have the right category identified on the IEP, because that drives instruction.
Yeah.
That's the direct link to what interventions are going to be used for that particular student. Other health impairment is a catch-all. Often it's used for kids with ADHD, right? That's where ADHD lands under the IDEA. And our kids, often have an overlap between a learning disability and ADHD. So there may be a temptation to move towards the other health impairment category. But as Angela said, what you want on your IEP is a more direct diagnosis of a disability category called the SLD. And what the legislation is proposing to do is to dive even deeper than that and get dyslexia as the identified category to better drive instruction. Does that help?
Yeah,
Yeah.
that's exactly right.
Okay.
Because
All right.
districts will try to do something different, and then that doesn't drive the instruction.
Right.
And what if you have multiple categories that you might qualify under? How do you prioritize? Or you put them all in there?
That's part of the team discussion in terms of how, if there are multiple categories, then there should be goals and objectives to address those.
Yes, so you can have a
Yeah.
primary, secondary,
Yeah.
tertiary,
Yeah.
and then I would just have them all listed, narratively too.
Yeah, and that way your IEP ties back to those disability categories is the way it's supposed to work, yeah.
Is the primary the one that drives the instruction more than the secondary, or are they both equal?
They should be equal,
Okay.
but in practical terms, the primary is probably gonna get more attention,
Okay.
so that becomes,
Yeah.
again, this is where your advocacy, and you guys have all been through it, which is why you're here. This is why your knowledge of the details and the rules of the game becomes important, how it works. So on page 7, you can see, just picking up on this trend, and some of these are older, from 2015, 16, 18, a lot of activity at the federal level around dyslexia in particular. I don't think the IDEA is going to change in terms of adding a category. In fact, and I mentioned this if you've heard me before, during the last time the IDEA was reauthorized, back in really 1999-97, in a substantive way, they talked about taking learning disabilities totally out of the IDEA. They tried to remove it entirely because half the kids, because it costs a lot of money.
Yeah,
So,
it's all money.
so Congress was like, let's just get rid of the problem by taking it out. So I don't, we'll see what happens, but what we've got going on here is a lot of activity around dyslexia. And you can see, these are important. Little opinion letters, these are those opinion letters I talked about coming out of the federal government. In terms of if you wanted to, advocate to have dyslexia in the IEP itself, the feds have basically said there's nothing that prohibits that from happening. So a district may say, we're gonna stick with the disability category of SLD. You can pull out this letter and say, yeah, but the feds say you can put dyslexia too. So it's just another piece of information to be aware of. And you can see as recently as May 10th, 2018, OSER letter to Zirkle. That's the Federal Office of Special Education Rehabilitation Services, for what it means. The question there was whether RTI could slow down the process of eligibility, and the answer is no. So RTI, is response to intervention in terms of how tiered instruction is what we call it in Massachusetts, and whether tiered instruction could slow down the concept of eligibility for kids with learning disabilities.
RTI is general ed, so.
Correct. RTI is general ed. RTI is one of, 30 seconds on this. Child's identified as having some potential issues around learning or reading or whatever. RTI says you roll in some interventions and see if that works. If those don't work, you roll in more interventions. If those don't work, you roll in more interventions. And at that point, you can assess eligibility. That's what RTI stands for. The shortcut to that is that if you're concerned, you can request eligibility determination at any time during that RTI process. That's what this is about. Okay? But we're kind of beyond that. So evaluations on page 8. The only thing I'll mention here is nothing really new, but I'll mention that there are 3 points in time when an evaluation must be conducted of your child: the initial eval for eligibility, the reevaluation, and an evaluation when eligibility is ending. That does not include graduation or turning 22. That's if they're terminating services early. That's not going to be the case for anybody in this room. I can't imagine that they would ever terminate services for kids that you have. But the reevaluation, well, I think if your child's here, it's going to be pretty hard to argue that they don't have a learning disability based on just the fact that they're here. So you're right. Anything can happen. Sorry, that's my hand. But it's a pretty hard case to make for that in that context. What I'd say about the reevals is that, and you may encounter this, every 3 years they're required to do a reevaluation in a more comprehensive way of your child. That right can be waived. If you wanted to waive, if everything's going fine and everything is up to speed, you can waive that right to a reevaluation. But the district has to initiate that and try to make sure that happens. Anytime the district, or that evaluation could be done earlier than that. So let's say you had your 3-year reeval last year, your child's here at Landmark, and they're proposing a reevaluation this year for whatever reason. They can do that, and you can consent to it. You can also not consent to it. So that's really your call. They can argue about that and take you to hearing about that. But they would have to be pretty invested to do that. So it's a judgment call on your part. If they want to do an evaluation earlier than the 3-year reevaluation, you can look at that and say, that makes sense to me. I want more information, more data. Or you can say, not really sure it's necessary. I'm very comfortable where we are, and deny that request for reevaluation.
So if you're within the process, though, of like the hearing process, or
Yep.
going to hearing, what does that look like from a hearing officer perspective?
Right,
You
so-
deny.
Yeah. So the question is, if in fact, in the midst of kind of negotiating or moving towards mediation or hearing, and the district asks for a reevaluation at that point, short of the 3-year eval, what does that look like in terms of the lens of the BSEA? And as Angela mentioned, back in the day, just to give context, I was an attorney at Disability Law Center for a long time too, representing kids with disabilities. And then I was the director of the BSEA and a hearing officer of the BSEA. So the question is, for lens purposes, it's a reasonableness question. It's a good question, and we'll talk about this later on. You do want to appear reasonable. You don't want to appear like you're being unreasonable in the bigger picture or the light. But it's still a balancing act of strategic decision making. You know, how often have the evals been done? Has this been done every year? Do you have a recent eval that was just conducted by an independent neuropsych? You know, it's a matter of context, I think, in terms of how it's all played out. You should look at it carefully. Yeah.
Can a district decide they don't want to do the 3-year testing?
No, they cannot decide not to do the 3-year testing. They have to initiate it. You can say, again, we don't think it's necessary. They would document that, but legally they have to initiate the 3-year reevaluation. Okay. For some of you who are here perhaps under settlement agreements, the district may have walked away entirely, right? They may have said, we don't want an IEP, we don't want to go to team meetings, we don't want any testing done by us, we're washing our hands of the placement here at Landmark.
But that's in the settlement agreement.
That's in the settlement agreement, right? So we don't even have an IEP, we don't have team meetings, it just is set up that way, because the district kind of says, we're done. Your child's at Landmark, they'll take care of the rest. They get hammered on their audit by the state for doing that. We get hammered on the audit by the state for doing that, but that happens sometimes, periodically. So the other thing to understand is that once those evals are done, you have the right to an independent educational evaluation. So every time the district does an evaluation, you have a legal right to get an evaluation paid for at school committee expense. There's a caveat to that. So if, for example, the district does their reevaluation, you get a neuropsych done, they do a neuropsych, you have 16 months from the date of that neuropsych to get what's called an independent evaluation done and paid for a school committee expense. You can pick the evaluator, you can pick the clinic, and the district technically is required to pay for that, but they pay for it within what's called rate-setting rates, which is considerably less than what the actual rate would be with a private evaluator. Unless you go to a clinic, like at Mass General or Children's Hospital, they are bound by rate-setting rates. So there's pros and cons in terms of how that actually plays out. It's not as simple and clean as it sounds, but it is a right that's available, and it's an important right for people who can't afford any resources that's built into the IDEA. I happen to think the independent eval, whether you get it paid for by the district or partially paid for by the district, whether you pay for it yourself, Angela's heard me say this, the evaluation is the most important piece of your case or whatever, portfolio, whatever it happens to be. If you don't have a good evaluation, you are dead in the water. You're not going to make any progress with the district, you're not going to make any progress in mediation, you're not going to make any progress settling or going to hearing. So it's really important that you find a good evaluator who's credible, knowledgeable, and can prepare a nice report that you can then use as a guide or a roadmap as to what your child needs. Without that, you are really not going anywhere. Yeah.
Just a quick question, do you have right for reimbursement if, say, your child has been tested 1.5 years before, and then like 1.5 years goes by and you say, well, I wanna see if she's making he or she is making effective progress?
Yeah.
But it's not time for them to reevaluate, do you still have a right to that reimbursement?
Yes, if the district has done the eval, say today,
Yeah.
for example, and 14 months later, you wanna check on progress, you have the right to request that. You have the right to actually go out and get the evaluator and then request the district to pay for it. But again, there's gonna be rate-setting complications with that. But you have 16 months.
Oh.
Anytime the district does its eval, you have 16 months under mass law to request that independent eval.
So what Dan is trying to say about complication is a lot of credible folks, private evaluators won't take rate setting. So
Maybe.
that kind of locks you out. And then like the big clinics, their wait list can be
Yep.
more than 16 months. They can be like 2
Mine
years.
took partial.
Yeah, sometimes
Yeah.
you can get a partial.
Yep.
Yeah.
They took it and then they sent me the bill for
Yeah, and it's called balance billing. I mean, fundamentally, some private evaluators will take whatever the rate setting rate is of $750 or $1250 or whatever they can get, and then they will balance bill you for the rest of the actual charge. Technically, that's not legal, but
So a lot of people do.
But isn't some of that reimbursable from insurance or covered by insurance if it's
so yeah.
bifurcated in the
So
right way?
here's my guidance on that, for what it's worth. Yes, some of that can be picked up by private insurance. The issue that you need to be aware of, depending upon the age of your child, is that private insurance also has caps. So there's an issue of how much you want to, they allocate X amount for services to pay for insurance claims for that child. And the issue is how much of that you want to eat up to use it to pay for an evaluation or something else before you hit the cap. So if you've got a 16-year-old and you've still got a lot of money under your insurance cap, sure. If you've got a 10-year-old and you may need more services for the next 8 years, maybe, you know, so that's a judgment call on that, but yes, you can tap into that. Yeah.
Try not to make this too personal. So hypothetically, if you're in the middle of negotiating and the school says, hey, it's time for the 3-year eval,
Right.
which the school has a history of not finding things that independent neuropsychs do find, is it appropriate to sort of agree to it with that caveat to say, I will agree to this 3-year testing, but I want you to know that I will also be pursuing independent testing at the school's expense? I'm just, is
Yeah,
that
so the question
appropriate to
is,
do that?
just so I can have it, you know, is if it's time for a 3-year reeval, is it appropriate to say, I'll consent to the 3-year reeval, but understand I'm gonna request an independent eval off of this? Doesn't matter. Honestly, it doesn't matter. You don't have to even tell them that that's part of the deal. You have the right to it. Remember I said this is an entitlement statute. Once you trip into eligibility, you're entitled to these rights. So whether you make it a condition of the reevaluation or whether you just say, go ahead and do the reeval and then a week later say I want an independent eval, you have the right to that anyways. Okay?
Just kind of piggyback on that. How is it best handled though, because they can't repeat the same assessment tools?
So that's the other issue, right? The other issue is that it's called a mirror image evaluation. I call it a mirror
Yeah.
image. The independent eval is a mirror image off of the original evaluation. That becomes a question for the evaluator. They can use different subtests
Right.
or different tests to get at the same information, but not repeating the same test.
I guess my question is, would it, if we requested as parents that our independent evaluator did certain testing, just because it seems that sometimes that independent evaluator might be a more objective lens than the in-house school
Sure.
testing, does that not look good if you were to go all the way to settlement? I don't know, our special ed director, I've understood that he likes to do what he wants to do. Does that?
Yeah, so repeat the question again.
Yeah, sorry,
I
I'm
kinda
just
lost-
like,
Yeah.
I went on and on and on. I'm wondering if it doesn't help a case if you say, I would not like the school to do certain subtests or certain
Okay.
assessments, I would like my independent evaluator to do those.
Right,
That's much
so
better.
yeah, so the question is if the district proposes test A, B, C, and D,
Yes.
and you say, I'm totally fine with A and D, but I'd rather have B and C done by an independent evaluator, that's a point of negotiation. I don't think that's unreasonable to have that discussion.
Okay,
And I don't think it would be perceived as unreasonable to have that discussion. I don't know where it would land, but in terms of what the decision would be by the SPED director,
Yeah,
Or
Yeah,
you could
yeah.
do your testing first.
yeah,
right.
Yeah.
I was just wondering if it mattered in terms of
Yeah.
the legal.
Perception.
No.
yeah,
Okay, thank you.
yeah.
I wanted to clarify for neuropsychologists too. I understand it's a conflict of interest if they work for the public school and can't do then a private neuropsych within the school system area, but it seems like it's still a conflict of interest even if they do it outside of their school district, but that seems allowed, that seems allowed.
Yeah, so a neuropsych is employed by school district A.
Yes.
And does independent neuropsych testing for a kid in school district B. Is that a conflict of interest? I'm not sure it would be, technically. I'm not sure it would be. Okay, one more, then we gotta keep moving.
Quick question, are these specific only to Massachusetts? What we're discussing right now?
The independent evaluation is part of the federal law. The timeline piece is
Yes.
specific to Massachusetts. The
Okay.
16-month is specific to
Okay.
Massachusetts.
And the rates,
And the rate
And the
setting.
rates.
and the rate setting.
That's,
of
that's,
Massachusetts.
that's mass law.
Okay.
Yeah.
Yeah.
Outside of Massachusetts.
Yeah.
So where in the law does it say a public school can deny an IEE as they file for the Board of Special Education Appeals within the 5 day? Is that,
So the one other layer here, it's a good question, is, you know, you can request an independent evaluation. The district has 5 days to respond to that. If they can say yes, or they can request a hearing with the BSEA to contest the request for an independent evaluation. That, you know, in my experience, that happens very rarely because, okay, twice, you're rare. But no, the cost of going to hearing to contest is more than we're just paying for it.
Yeah, sometimes I've seen it used as like an intimidation.
Right.
They'll have their attorney file
Yeah,
and then it gets resolved.
yeah, so, good point. Okay, so assuming you have the evaluations done on page 9, you can see the team process and the IEP. I'm not going to reference a lot on that page because you've all been to team meetings. Nothing's really dramatic there. The IEP, you've all seen IEPs, but those are the elements within the IEP document itself. What I will note on page 10 are issues that you can see key new legal points. 4 through 7, if you look at those over the past X amount of years, from 2017 through 2018, they all have a common theme, right? They all deal with transition, okay? So the point there is that both the federal government and the state government are focusing really heavily on transition planning, and you should as well. As you're, not so much for elementary, middle, but as your kids hit age 14 in Massachusetts, transition planning is required to start to happen on the IEP. And most of the litigation activity around the country is dealing with transition planning or the lack of transition planning. So it's important that you advocate carefully and constructively with the district to get good transition planning built into that IEP to ensure that the next step beyond high school is a successful step for kids, okay? A lot of activity around appropriate transition planning, a lot of guidance issued by both federal and state departments of education, so just be tuned into that, okay? Federal law says 60 and above, Massachusetts says 14 and above, so just, that's the difference again. State law gives more protection, so state law controls. Okay, page 11 is services. Now you've got the services layered in here. The bottom of the page, this is the whole concept of appropriate education. Under the IDEA and state law, once your child's eligible for services, they're entitled to a free, appropriate public education. And the key word there, not so much free, it's appropriate. It's what is an appropriate education, and this is where you're probably getting into some tug of wars, with your district around, is my child getting an appropriate education, or what services are they getting? Are they meeting his or her needs or not? And that becomes the flashpoint. The related services part is the transportation piece for most of you guys. It's the buses that get stuck waiting in line over EMS or waiting in line here at the high school. Sometimes, and you may have encountered this, districts will say, okay, we will pay for the placement, you figure out the transportation. So they try to split that cost with parents and settlement agreements as a way to try to minimize their exposure to dollars. Because transportation, as you're well aware, can be pretty costly, sometimes more expensive than the placement at Landmark. So that's one of the points of negotiation, but that's a related services piece that's part of the IDEA. If we look at the key legal points, last year I talked about Andrew. Andrew was the Supreme Court case a year ago that redefined the concept of what's an appropriate education. Historically, it was the Rowley case, which defined what was an appropriate education. The key thing about Andrew and the takeaway is really, it has to be a meaningful education. The court originally said it could be a minimal education, and the Supreme Court said that's just not the case. It has to be a meaningful education, and that, it turns out, has carried some weight. When it first came out, a lot of lawyers were like, this doesn't really change the game too much, but the more it's evolved over the past year, the lower courts have said, yeah, it does make a difference, that meaningful can be tied to an individual child's potential, which is an important piece for you all to understand, right? Because kids with learning disabilities have high IQs, they're very bright, they're very smart. The issue now is what's a meaningful education for a child with that capability? And that does change the lens. Used to be, there was a case out of New Jersey about 10 years ago. It was kind of an outlier on that issue. It was a landmark case called RJ versus Ridgewood. And that was the first time a court ever looked at, well, let's look at the kid's individual capacity to judge whether or not they're making effective progress in getting an appropriate education. People thought that was an outlier. This case, Andrews, seems to trend in that direction. So it's an important piece to file away about meaningful education in the context of what's an appropriate education.
And there's an advisory out from DESE on.
Yeah, there's an advisory out from DESE, and there's also a really good advisory. Listed it here. Yes, I don't. It was last year. There's a really good advisory issued by the Federal Department of Education on the Andrew case. You can just Google it. The Federal Department of Education, Andrew advisory, and it'll come up. It's a really good Q&A. It's actually very well done.
So is meaningful, like, they're making progress, like the ability to make progress?
You really have to make progress. The question is, what is mean? This is where it gets, this is where you start to talk about it. Yes, I mean, clearly they have to make progress. The issue is, there's minimal progress, and then there's meaningful progress. This is what the court looked at. Because the lower court had said, minimal progress is totally fine. Even if they just make a little bit of progress every year, that's all the IDEA requires. The Supreme Court said, that's a joke. Honestly, they actually said it pretty bluntly. That can't be true. It has to be meaningful. So how you measure meaningful for
And
each
ambitious
individual
is the
child.
other word that they said.
What?
The ambitious was the other word that was used in that.
Yeah. So meaningful is really subjective, but you need to have data. That's why the independent evals become really important to feed into what is the measure of progress for this particular student. Okay? But it's important. You can see the impact of that. The case below, number 2, same case. Supreme Court said to the lower court, we're sending this case back to you to reevaluate your decision in light of what we just said. And the lower court, when it got it back, said, we got to change our decision. That we found in favor of the district under our standard of minimal progress. When we come back and look at it now under the new Supreme Court standard, we need to find in favor of the parents. So you can see that it does make a difference, and the cases in Massachusetts have started to adopt that line of reasoning. So it does raise the bar, and that's a good thing. Rachel H. is a Hawaii case, but it's important to understand, and this could, I'm keeping an eye on this one in terms of landmark kids. Because here's the deal. They talk about what's called the location of services. And what they're saying in that case is that it's actually the type of placement versus the location of the placement. And if you think about that, that means the type of placement for a child here would be a placement that has language-based programming. So if a district makes the argument that we have a language-based program with capacity to meet your child's needs, under this analysis, it's not the physical location of the landmark, it's the type of placement where the child would receive the services. So it's a little different lens that needs to be paid attention to in terms of what a district might argue using this case as what's called precedent to say, hey, it's not so much the physical location of a place like Landmark that has language-based programming, it's the type of placement the district proposes that has language-based programming. So there's a deeper dive to that when you actually get into the nitty-gritty, but it raises an issue that's a little complicated.
You say, does that come into the least restrictive concept? Like,
The least restrictive would layer into that in terms of, if we can provide the same level of service in the least restrictive environment, then yeah, then they're starting to line up the case on that argument. Okay. So just be aware of that, yeah.
So is that meaning like this person was in Hawaii, but like the appropriate education is here in Landmark, so that district would pay for them to come so visit this? Or is
No, it means the
Yeah.
opposite. It means that they could say that we have something in Hawaii, the same type of placement that Landmark offers. So therefore, there's no need to go to a location like a Landmark. We can do it in-house.
So what about quality when you come back?
So that's the deeper dive. The deeper dive, and we'll talk about this when we get to placement, because we're just on services right now. The deeper dive is what is the program that they're offering versus the other program like a Landmark or a Carroll. Okay? So just be aware it's kind of a different kind of analysis. So if we keep going, there's a lot of extra cases here that you can read if you want. Synopsis of cases. We get to page 14. Let's talk about placement. And this is where least restrictive comes in. So the concept here is that we know what services your child needs. Now we've got to figure out where to deliver those services. And if you're on IEPs, you've been through this process in terms of getting your child to Landmark. Right? Sometimes the districts say, we totally agree, he or she should go to Landmark. Sometimes not so much, right? And you end up in mediation or hearing or something along that kind of line. But the thing that's in play here is how do we get that appropriate education that's meaningful in the least restrictive environment? And the least restrictive environment starts out with a regular ed classroom with 20 students and one teacher, goes to a classroom like that with an aide, goes to pulling the child out for 2 hours a day for reading instruction, to moving them to a separate program within the school, to then moving them to a day program like Landmark, to moving them to a residential program. That's the spectrum of least restrictive to most restrictive. The Landmark residential program is considered the most restrictive under the IDEA because it's all kids with the same disability, it's 24/7, it's much more isolated from the regular ed classroom with 20 kids with diverse profiles. Okay? So the balance here is at every team meeting, which we may convene every year, the district will look at where can this child get the appropriate services they need in the least restrictive place. And they may argue at a team meeting that, okay, your child's doing really well here at Landmark. They're getting B's and maybe some A's. And therefore, they don't need this type of highly structured setting anymore. They can go to something less restrictive back in our public school with programs that we have available because Landmark is consulting with us, right? So that's the balance test that's going on here when we talk about least restrictive and placement. Recognize the test that they're using in their head is if you're a parent, you need to be able to prove the public school program is not appropriate, meaning the NRU standard, right? That the public school program is not providing a meaningful education for my child in light of their capacities, and the private school program like Landmark or Carroll or whatever is providing that meaningful education in the least restrictive environment. Those are the two prongs that you have to meet. The district is looking at it entirely different. They're saying we need to prove that our program is appropriate under NRU and that Landmark is not appropriate under NRU. And they may argue that Landmark isn't appropriate because it's too restrictive. That's part of the mix of their argument, okay? As you all know, these are tough cases. This is where that evaluation piece is critical. If you don't have an evaluator who can credibly argue or advocate with you in terms of what your child needs in this context, then you're not going to get the Landmark placement for a kid. Okay? Yeah.
Just real quick, I'm just curious to where the emotional piece comes in. Like say if you have a child, hypothetically, in the public school system, they're being pulled out 75% of the time, they're not in with the regular classmates, they're coming home and they're great at school. I mean, they're bubbly, sweet, but then they come home and they've got this edge about them, and as everything digresses, and you try to
Yeah, no
guiding
question.
your kid,
It's-
like,
it's-
and they're
it's-
like, I hate not being with my friends, I'm pulled out all the time, I don't see anybody, I'm behind in the class, regular classroom.
And, you know, I hear that all the time.
Is that
from
legal,
kids.
like, is there a legal stand there?
Yeah, so here's the deal with that. You know, legally, it's not part of the specific analysis. However, I can tell you that just from experience as a hearing officer and at the BSEA, it's a factor. You know, that hearing officers will respond to that kind of, and mediators, to that kind of a concern. You know, because they understand the dynamic that if kids aren't doing well social emotionally, that's gonna directly impact their ability to learn, right? So there's a direct link to that, but that again is why that evaluator has to make that, it's not enough for you to go in, you can go in and say it, right? And that's gonna carry some weight,
Right.
but it's not gonna carry the weight of an evaluator who says,
Or a
if we
therapist.
don't.
Therapist.
Or a
So
therapist,
a
yeah.
regular therapist is
Oh.
what I would suggest, so
Yeah.
like having, and then they can
Write
write
a letter.
letter or,
Or testify.
yeah, or testify.
Yeah.
You're not enough.
Yeah,
Yeah.
I know that.
Sorry.
Sometimes, you know, I will admit that sometimes as kids are older, you know, they testify.
Testify themselves.
Yes.
That's,
they
and that's a
testify.
judgment call on your part, entirely up to you whether you want to expose them to that kind of gruesome, honestly, hearing process. But sometimes kids do testify to that.
In lieu of that actual testifying, they
Yeah.
could do a affidavit? Is that,
They could, but you know, they could, it's not gonna be as powerful,
No.
well,
honestly,
yeah.
and it's also.
I'm just thinking of the emotional needs of the students.
Absolutely, yep, I mean, they could.
Protecting
It wouldn't do
them.
it, no harm, no foul, it can go in, you know, the other attorney might object to it, and
Well,
that's
that
a
will
different
happen.
question, you know. in terms
Can
of-
you talk about it, I'm like a hearing officer finding your experts uncredible, like that is possible.
Or incredible.
Oh, incredible, sorry.
Very incredible.
I'm,
Yeah, so,
not
so,
credible, not
so
credible.
one of the issues is, you know, if you bring in an expert, and this is where your networking becomes important. Because, let me, you know, like anything else, and you've heard, those of you who've heard me talk before, there are good lawyers and there are bad lawyers. There are good evaluators and there are bad evaluators. And the trick is to find a good evaluator who is credible. And if you actually, and I reference that in some of these little bullet highlight decisions, some evaluators just don't do a good job. They have cookie cutter evals, they forget to change the names in the word processing system, you know, and they use tests that are not recognized, or they have limited expertise around kids with learning disabilities, or they overstep their bounds in terms of trying to comment on maybe social emotional pieces that they're not equipped to testify about, and they get carved up on cross-examination. So it's important to find somebody who is credible, who is recognized. You can actually, this is something you probably wouldn't want to do, but I tell lawyers to do this. If you actually flip through the BSEA cases for 1 year, if you read all 40 decisions in 1 year that come out on average, they tell you, I mean, the hearing officers are pretty blunt about this evaluator was not credible because you will see the same names.
Yeah,
And you
it's
will
in the
also see the
summaries.
same names about, you know, who is credible. So, you know, just something to bear in mind. There's some well-known names out there who turn up all the time, who I can guarantee, when a parent calls me up on the phone and asks for advice, and I ask them who the evaluator is they're working with, I can tell almost immediately if they're gonna succeed or not, based on knowledge, you know? And I can't tell them, you know, ethically that that's a really bad choice.
Yeah.
But, you know, I know that they're pretty much doomed from the get-go, because that evaluator is not gonna have any credibility to BSEA. So, or, more, you know, the layer below the BSEA to also have to understand is that with districts as well. I mean, districts, they know that some evaluators are gonna be straight shooters and call it like they see it, and trust their recommendations. And other ones, they're immediately gonna say, oh my gosh, they've got this evaluator, shut it down. You know, we're not gonna listen, no matter what they produce.
Yeah.
So that's just the dynamic that you have to try to navigate.
Are you calling the evaluators the neuropsychologists for the
Yeah.
most part?
Yes.
Okay.
Yes.
Or if you have an ed evaluator going in to do like an observation, who's a special educator, make sure they've testified before. It's really important.
Yeah.
And in the summaries, you can So you don't have to read the whole decision, you can sometimes go to the summary and you can find that who's not credible.
Yeah, I mean, I always ask, when I'm actually identifying an evaluator to work with on a case, you know, I've been around a while, for better or worse. So I kind of know who, every lawyer has their own little file of evaluators that they guard really carefully. Because it's not easy, because you have to get that commitment, as Angela said, to be able to go to the limit. You know, it's not just writing the eval, it's being willing to go to a team meeting, it's being willing to go to a hearing and testify.
Some people won't testify.
Right, some people won't leave their office, they'll test in the cubicle or the office, but won't go to the team meeting, and that's, in my mind, that's problematic. So, okay, so if you look on page 15, a couple of pieces here on placement decisions. There's two here that I'll just reference briefly.
What page you on?
At the top.
15.
Page 15, sorry. Hamilton wanted at the top. The only thing I'll note here is there's a couple of things in play, and Westboro is the one after it. And Angela raised this a little earlier. In a close case, you know, where it's really close in terms of where this child should land on a placement case, the reasonableness of the parties can play a factor. That's called balancing the equities. It's really, you know, if in fact one party looks unbalanced, like they really have been not helpful in this process, whether it's because they refuse to consent to things, whether the district deliberately does weird stuff, in a close case, that can tip the scale. And that's what you see, the discussion in both of these cases, Hamilton Wenham and Westboro, where the parents' actions didn't help them in the long run. And they thought in their hearts, I'm sure they were doing the right things, but objectively, it didn't appear reasonable, and it ends up undercutting their claim in a close case potentially. So just bear that in mind. It's a perception of reasonableness that you always want to build along the way as you have a case. A lot of other cases here. On page 16, a couple of others. Boston and Nantucket, number 6 and 7. Boston again, close case with learning disabilities. They lost because of that balancing of the equities, the reasonableness of the parties. Nantucket, here's one where you could pull about an evaluator.
Yep.
This is one where they drill down deep, the hearing officer, and walks through why this evaluator didn't do a good job. And as a result, parents lost the case. Okay? So that's an example. You can see these cases. The hearing officers do this deliberately. They're trying really hard to send a message out to people that, you know, look for these cues if you're going to come forward to see us. Okay? All right, 17, we're going to move to procedural safeguards. The one to recognize here is what's called stay put in the middle of the page, E. Stay put really deals with the issue of if a child is here at Landmark and the district proposes to bring that child back and you reject that proposed placement, then the child stays at Landmark until that dispute is resolved. That's what stay put means. So the last agreed upon placement stays in place until the dispute is resolved. So you have an IEP, your child is placed here at Landmark, the IEP expires next year, at the end of this school year. You have a team meeting in April or May. The district says, we think they're making effective progress, we want to pull them back to the public school district. If you reject that proposed placement under Mass law, rejection of the IEP, that proposed IEP, the last agreed upon placement, which is Landmark, stays in place until that dispute gets resolved. Which means functionally, if you are smart enough, you can delay the process and get another year's placement. Okay? The thing you need to be aware of in your settlement agreements is waiving stay put. Districts will generally always ask you to waive stay put. So it's a key bargaining chip, because the implications for them, you could get a placement here for a year. If you have a really quote unquote good attorney, they can get you 2 years out of it. But stay put's an important legal right. One of the key legal rights in the IDEA. That is not available under Section 504. Okay, that's another distinguishing point. Stay put is a right that's only under the IDEA, special ed, and not under 504, sorry, more caffeine. All right, if we keep moving along here, I'm going to point to a couple of miscellaneous pieces before we wrap it up. On page 19, and these are all technical procedural things, and there's a lot of these at the BSEA. I'm just going to highlight a couple of them that might be interesting to you guys. Number 6, in the middle of page 19, Norwood. This is where there was a mediation agreement reached between the district and the parents. And it's actually a landmark case. And there was a dispute that arose in the middle of that agreement about the placement, about services. And functionally, they've tried to go back to the BSEA to get that interpreted, and the BSEA said, we don't have any authority to do that. You gotta go to court. So my only point here is that when you sign those mediation agreements or settlement agreements, really understand what you're signing, because they're binding, and you're locked into those, and you can't go to the BSEA, which is less, believe it or not, less burdensome than going to court. BSEA is saying, we can't interpret those. They're
So it's
outside
after
our,
they've signed the settlement,
Yeah.
and they've decided, oh, no, that's not what we want.
right,
Yeah,
right.
that's why you need to be,
Which
like,
happens
go
to me
over
with
with your attorney, make
Yeah.
sure you
Make
are
sure you
fine.
get it, yeah, because
Every
otherwise,
piece of it.
otherwise you gotta go to court to get it figured out, and that's gonna raise the cost.
Contract law.
It's contract law, that's exactly right, okay? Number 3 at the bottom of that page, Hamden, Wilbraham, basically talks about awarding credits and promotion. The BSEA, for what it's worth, doesn't have any authority over that. That's a school district or school issue. It's not an issue for that. Top of the next page, let's talk, yes,
Sorry, where are the BSEA decisions published?
you can go, they're semi-published online. They used to be online all the time. There was a reporter that's published, but you can actually,
Which reporter is it?
it's called Land Law. It's called the Special Education Reporter. It's published by a company called Land Law.
Can you get them with the same number?
Yes, yes. There is a digital version too, but you have to have a password and stuff for that. Okay. Top of page 20, the Duxbury case. You recognize this one. When you are, and this is in combination with the Newton case down below, a couple cases down. Your communications with an advocate are not what's called protected from discovery. So whatever you write to that advocate in email, or even text, are what's called discoverable. If you have litigation, if you get into a battle with the district, the attorney for the district can get access to that dialogue. It's not protected. If you're sending it to a lawyer, that's different. That's attorney-client privilege, it's protected. But transmissions to an advocate are not protected. But also be cautious and recognize that even if you send to an attorney perhaps, but clearly to anybody else, any email that you send could be pulled out and used in litigation. We get discovery requests probably once or at least probably 2 to 4 a month from school districts with subpoenas asking for any email exchanges between the parents and the admissions office or school personnel, okay? So just understand
And
that
if you
what
copy
you,
them onto the attorney, like if you email
If
your
you
attorney and copy
you
the
get
admissions
still
officer,
not-
or the whatever, then you're,
It's not protected.
right.
yeah, so just be aware that what you write may turn up somewhere else, yeah.
I've always been a little confused by that, because as a parent, I'm supposed to be advocating for my kid. I
Yeah.
have mandatory requirement to actually interact with the people who I hope will help me interpret what's going on with my child.
Yep.
So what kinds of things will actually get me into trouble? Because just saying, I'd like to make an appointment and do my
That's not,
appointments,
obviously,
right,
those
obviously should
kind
be
of
fine.
things, you know, do what you would generally do. It's when people, you know, type 4-paragraph kind of things that are, for lack of a better term, not a good term, kind of off the rails. They're not relevant, they're not targeted, they're more like talking about personnel. or-
Rant.
It's a rant, yeah. That's what it would.
So
Or-
my word rants, I'm
Or
probably
anything
okay.
you wouldn't
It's
want,
strategy, yeah.
anything that you strategy, anything you wouldn't want publicly known about your child, I would pick up the phone.
Yeah. mean, I always tell our faculty, I do a workshop at the beginning of the year, you know, if you write an email, if you wouldn't want to see it on the front page of the Boston Globe, don't write it. Because that's where it can end up, this is not going to end up on the front page of the Globe, but it can end up in the context of litigation, and I just think, just be sensitive to that, because we're seeing more and more activity around subpoenas for emails and text messaging and all that kind of stuff. So just, that's why I bring that to your attention. The Medford case on page 21, then we're going to stop shortly. 2017, Medford just recognized that there's the advance notice of unilateral placement. You know, if you have another child who might be coming to Landmark or whatever, you have to give advance notice to the district that you intend to place the child here. Otherwise, there's procedural hoops you're going to have to go through to make sure you get reimbursed for that. Okay? The rest of this is all discipline stuff, which we're not going to talk about because it's not relevant to you guys. On page 26, two issues here, just to be aware of this trend. Districts are more and more often requesting attorney's fees claims against parents in cases. So that means they're asking that you be required to pay for their attorney's fees if they win the case. So if you go to hearing and you lose, they're asking that you pay the attorney's fees for the district as well as your own attorney's fees. Those very, very, very rarely succeed. And you can see in the Falmouth, Maine case, they lost, the district lost. However, in Lincoln-Sudbury, the district won. But that has to be when the parents are really, if you read the case, unreasonable in the context of the judge looked at it, the hearing officer looked at it and found the parents to be unreasonable. In those situations, then the award of fees might happen. It's pretty unlikely, this is a rare case, but just be aware that it's out there, okay? Last page, 27, is just some BSEA data in the middle of that page, just so you see the context here. About 11,000 rejected IEPs last year. Something called facilitated IEPs, 118 of those. You can actually bring in somebody from the BSEA to deal with a contentious IEP meeting to try to get resolution. About 700 mediations, about 22 decisions last year, 500 requests. And then the trends there at the bottom. And actually, if you do want to read about those trends in a little bit more detail, there is that amazing blog post about that. All right. Any questions about any of this stuff? Yes.
I have a question about discovery.
Yeah.
When you said the attorney-client privilege,
Yeah.
if there's another third party involved in that email, for example, there's no more attorney-client.
Correct.
Okay.
Yeah.
That's-
So
a lot of people are unaware of that.
Yeah. All right. Thank you so much. Thanks for staying late.
Thank you.
Mary, Sherry has one question.
I have a question.
Yes.
I read something on a Facebook page
Yeah.
that was for parents recently about a child find mandate.
Yes.
Can you speak about, like, we have a son who wasn't identified
Yeah.
for a long
Under
time?
the IDEA, this is called Child Find, requires the district to identify kids who might be eligible for IDEA services. You will see postings around town, literally, in newspapers, like we're having a clinic, a screening clinic, or something like that. Their obligation is to find children who should be eligible, whether they're in public school or whether they're in private schools within the district. So if they haven't identified somebody who should be eligible, there's potential remedies for that in terms of what's called compensatory services. So they have an obligation to screen and find. Okay. Good enough?
Thank you. Are you ready after class?
We're going off to class.